Friday. Welcome to our presentation titled For Sale, Positioning the Sale of Your Startup. My name is Bree Allen, and I am a third-year law student at the BU Startup Law Clinic. And now I'll allow my colleagues to introduce themselves.
Hi everyone, good afternoon. I am Ashley and I am also a third-year law student at the clinic.
Hello, I'm Elvis. I'm also a three-year law student at the clinic.
Thanks, guys. So we just ask everybody to please hold any questions that you have until the end of the presentation. Okay, so to start our discussion, I'm going to briefly discuss what it means to sell a company and the basic types of business acquisitions. So what does it mean to sell a company? Just as you need a plan to start a business, you may also need a plan to exit your business. And one profitable exit strategy is selling your company. The sale of a company follows the same basic structure of any ordinary sale transaction. However, unlike a grocery store selling an apple to a customer, the sale of a business is much more complicated. The main reasons for this complication are that businesses consist of both assets and equity, may have debt, and involve many different parties and stakeholders. When you sell a company, you are really selling its stock, meaning selling the ownership of the company or its assets. Assets include tangible property such as machines, real estate, or cash, and also include intangible property such as trade secrets and patents. Also, when you sell a company, the purchaser may have to consider the company's debt and its valuation. This is especially important for stock sales, which we will discuss, as the purchaser assumes all liabilities of the company via equity ownership. Lastly, selling a company is complex due to the different stakeholders involved, including founders, managers, and shareholders. These parties may disagree on issues such as price, who the right purchaser is, and whether or not to sell at all. Next slide. Next, there are a variety of reasons why you might want to sell. The first category is having a plan from the start to sell, the develop and sell model. Sometimes founders of a small business know from the start that they plan to sell. Although this could be the case for many different types of startups, this is often the case for technology companies. For example, you may want to develop some new technology and form an entity to protect yourself from liability and to own and protect the IP as you develop, use, and improve it. However, you plan on one day selling that IP, which would be an asset sale, or the entire company, a stock sale, and exiting. This model allows you to have time to develop your invention, profit off of the invention, and exit to begin working on something else. The next category of reasons you may want to sell involve a change of course, specifically unexpected or disruptive events. These include founder's illness or death, burnout, founder's new employer has disallowed involvement in your company, company is no longer making enough money, or conversely, the company is at a high point and it's a prime time to sell, and also partner problems and disputes. Sometimes what happens following an unexpected or disruptive event may be laid out in company documents, such as bylaws, LLC operating agreement, or shareholders agreement. So for example, sometimes when a founder dies, the company must be sold. And other reasons in the change of course category include other founder priorities. And these may include that founders have obtained jobs they are focusing their time on, founders want to invest in a new venture, founders want to explore a different line of business, or founders just want to cash out for other financial reasons, and also retirement. And lastly, you may receive an unsolicited offer to purchase. So imagine you have a very cool watch that you love, and a friend has been eyeing your watch and asks you if it's for sale. You would say it's not for sale, but if your friend explains to you that they would pay 3 times the amount you bought it for, you may start to consider selling it, and the exact same thing can happen with a company. Next. Once you have decided to sell, you must set up your selling team. The most valuable members of an acquisition team include key company personnel. So management is normally in charge of providing projections and valuation information and can often add value to a deal by staying on post-closing. So it's important that they're active in the sale. Also, the board of directors should be on board with the transaction, as the board must approve of acquisition contracts and transfers. You also need to get an attorney. It's vital. A specialized M&A attorney or firm can help maximize the value and terms of your sale. And you should also get a financial accountant. Accountants can assist you with financial due diligence, help you clean up your financials so you are well positioned for a sale, and can advise you on structuring the transaction. And the last most important person to get is a tax expert. And your tax expert may be your accountant, but it is really important to have sound tax advice. So you might look into getting a specialist in tax. So aside from saving your company money, tax repercussions will often be the driving force in the structure of a transaction. So it's really important. And then, although not necessary, you should consider getting an outside business valuation expert. And business valuation experts are uniquely qualified to put a value on your business and can ensure you do not sell for too little or go to market too high and drive away potential buyers. And lastly, you should consider getting a business broker. So if you don't already have a buyer lined up, a broker can contact likely purchasers directly and tell them key facts about your business. Next slide. Oh wait, sorry, Elvis. The two main types of acquisitions most likely applicable to small private businesses include stock purchase and asset purchase transactions. Now, next slide. Sorry about that. So the first acquisition type is a stock purchase. In a stock acquisition, the buyer acquires all of the outstanding stock of the target company directly from the target shareholders. So what does this look like? Take a look at my little chart here. So your company remains a separate legal entity from the purchaser. The target's existence continues following the transaction. Only its stockholders have changed. If the purchaser is an entity, it becomes what's known as the parent, and your company becomes the subsidiary. If the purchaser is a person, they become the sole controlling shareholder of your company, and it'll be owned by them. So, yeah. Next slide. So as shown in the graphic, for a buyer to acquire all of the target stock, each target shareholder needs to be party to a stock purchase agreement. The buyer acquires all or substantially all of the stock of the target company's shareholders. All of the assets, rights, and liabilities remain within the target as a legal entity. The pros to this structure are that it's simpler than asset acquisitions, as they generally only require a stock purchase agreement and related documents. They also generally do not require assignment of contracts. A contract assignment in a sale is when your company has to assign a contract it is party to, such as a loan agreement between your company and a bank, to the purchaser to replace your company as party. However, this is not required for stock purchase because the company remains party to all of its contracts. Again, only its shareholders have changed. The entity remains the same. Also, stock purchase sales do not allow the buyer to pick and choose which assets and liabilities they're taking on because they're just, acquiring stock. So the selling company won't get stuck with remaining assets to sell or liabilities to settle. And cons here are that if there's a lot of stockholders, it may become cumbersome and there may be holdouts and long negotiations. So for this reason, companies will often choose to go with the sales structure known as a merger, which allows the sale of 100% of stock without requiring all of the shareholders agreeing to sell. Under a traditional stock sale, when some shareholders do not agree to sell, the deal may not happen if the buyer wants to acquire 100% ownership, which is often the case. And conversely, asset sales and mergers, both to be discussed, generally don't require all shareholders to agree. Instead, dissenting shareholders may be entitled to what's known as an appraisal remedy, depending on the state, which means that a stockholder who doesn't approve of a sale can receive compensation if a court believes that the company or its assets were worth more than what they were sold for. And it's also important to mention that a stock acquisition could include buying over 50% of the company, so the buyer has effective control rather than 100%. However, this presentation is focused on full sales. That way, founders can fully exit. Next slide. So the second acquisition type is an asset purchase. In an asset acquisition, the buyer identifies the specific assets and liabilities it agrees to acquire and assume, subject to any liabilities imposed on the buyer as a matter of law, which sometimes happens. You have to acquire certain liabilities. And this is different from a stock acquisition or merger, where the buyer cannot pick and choose the assets and liabilities they want. So what does this look like? Take a look at this chart I have here. Your company survives after the transaction, but most or sometimes all of its assets and liabilities have become assets and liabilities of the purchaser. Your company is left essentially as an empty shell, possibly with certain assets and liabilities remaining. After the company is left as a shell, it sells off any of its remaining assets, settles any remaining liabilities, and distributes the remaining cash to shareholders by liquidating. Next. So the pros to this structure are that it might be easier for you as a seller to find a buyer, as a buyer can pick which assets and liabilities they want to assume. Also, it normally does not require every single stockholder to agree. And as mentioned, in some states, dissenting stockholders in an asset sale may be entitled to appraisal rights. And the cons to this are that asset sales allow the buyer to pick and choose which assets and liabilities they are taking on. This means you may get stuck with remaining assets to sell and liabilities to settle. Also, it is more complex than stock acquisitions as they require a separate transfer of each of the identified assets and liabilities of the target company. So asset sales require deeds for each piece of real property, trademark assignment for each trademark, assignment and assumption agreements for all contracts, and a bill of sale for other tangible or intangible property. Also, in general, you will need a separate assignment contract when there's a third party or government involved, such as a bank. And lastly, an asset sale is also likely to require third party consents if contracts contain clauses disallowing assignment, which are known as anti-assignment provisions. So although there are benefits to asset purchases, they are a lot more complicated than stock purchases. Next. So aside from the main types of acquisitions we'll be discussing, there are other acquisition types out there, two of which are stock and asset combinations and mergers. And although complicated and relatively uncommon, some companies do go with a combination of stock and asset purchases. However, we won't go into the details because they're pretty complicated. And then lastly, although the most common method for acquiring a public company, mergers are sometimes used for acquiring private companies with a large number of shareholders. And as discussed, a merger would be used if it's infeasible to enter into a stock purchase agreement with all of the company's shareholders. Next. So we have a little question here for you guys, if you can just answer the question in the chat. So which acquisition type is this? Your company remains largely unchanged following the acquisition, and it is now considered a subsidiary of the purchaser. Only its shareholders have changed. So in this hypo, the company is the exact same. The only thing that has changed is who its shareholders are. So is it asset purchase or stock purchase? Let's see. All right, so we have 2 for A and 1 for B. So the answer is B. So it is a stock purchase. So if you remember, a stock purchase is when the only thing that has changed is who owns the company rather than the aspects of the company, such as the assets and liabilities it owns. So in this situation, the company is the same, just the owners have changed. All right, so now I'm going to turn it over to my colleague, Ashley. Thanks so much.
Now, keeping in mind Bree's wonderful diagrams on asset and stock purchases, let's take a look at the buyer's point of view in light of both types of sales. In an asset purchase, the buyer purchases specific assets and assumes specific liabilities. This might be attractive to the buyer because it can pick and choose valuable assets and less risky liabilities. However, this might be a bad choice if the buyer really cares about the price, as the seller may be able to negotiate a higher price in an asset purchase. In a stock purchase, the buyer purchases, don't forget, the entire entity, right? So it is simple and straightforward. Nothing needs to be reassigned or retitled. But the issue with a stock sale is that the buyer ends up with potentially unwanted and risky assets and liabilities. I will discuss different types of buyers in further detail later, but just kind of a general overview, employees and strategic buyers tend to prefer asset sales. For example, let's say you are a co-founder of your company and you created a really important technology that you had initially assigned to the entity when it was formed. And as a side note, the clinic does that in the form of IP assignments. So later on, you can buy back this asset in an asset purchase. Financial buyers, however, generally prefer stock purchases because their role is that of a passive investor. Next, please. In a stock sale, you might be wondering, what do founders receive? And the answer to that is based on the buyer's form of payment. Founders will receive either cash, stock, or a combination of both. If acquired for cash, you get money for your outstanding shares and vested options. If acquired for stock, you get the stock of the acquiring company according to the agreed upon ratio. And if acquired for both stock and cash, you get a portion of the equity is cashed out and the remainder is paid in stock according to the agreed upon ratio. You essentially get a combination of both. Next, please. All right, let's take a look at a little hypothetical. Who can be your potential buyer? You are the CEO of a startup called Skin in the Game that has a valuable drug which helps tighten skin and reduce wrinkles. Your team would like to sell the venture because you do not want skin in the game anymore. Which of the below could be a potential buyer of the venture? A competitor called Beauty is Skin Deep. B, a co-founder. C, a private equity firm, or D, all of the above. And this is low stakes, so no worries if you guess wrong, not expecting right answers, but give it a try. All right. All righty, thank you for all the answers. And the answer here is D, all of the above. The good news is that there are many possibilities for you in terms of potential buyers, but as one of the audience members noted, there are always exceptions. And a caveat worth mentioning is that the venture's potential buyer might be limited based on any prior agreements with, for example, co-founders in the form of employment agreements. Therefore, it's important to ensure that when you draft or enter into agreements with co-founders, your entity reads, you read and negotiate all the provisions carefully with an eye towards the future. For example, eventually selling your entity. Next, please. Types of buyers. As mentioned in the previous slide, your buyers might be individuals, they can be entities, they can be employees or just individuals looking to invest, and can even be your competitor. While this list isn't comprehensive, let's go through a couple of common buyers. First is key holders, employee buyout. An employee or co-founder who is already in the internal management of your team may be beneficial because they can carry out the vision and success of your company if you choose to exit your venture. Strategic buyer, competitors that are in your field or large businesses that want to enter a new market or offer a new product will assess how well your business fits into their long-term strategic plans. They look for things such as synergy. So synergy is the concept that the combined value and performance of two companies is greater than each of the separate parts. So if your venture fits into your buyer's long-range plans, they may pay you more than other buyers. Financial buyers, they are investors who are interested in your company's profitability and stability. They're looking for well-managed companies that require little oversight. For example, private equity firms, they're passive investors that depend on management to grow the company and generate returns. You might be wondering where you can, meet these potential buyers, and the answer to that is network. So, there are various methods of building and expanding your network, some of which you may be already doing now. LinkedIn, industry panels and talks, professors, mentors, and bizbuysell.com is a website in which you can connect with potential buyers. It is always helpful to get to know, potential buyers or the buyer's management team ahead of time, since you will be entering into such an important transaction with them. Next, please. Negotiating price terms with buyer. Board directors of company owe its shareholders certain duties that you should be aware of. And this is particularly important when it comes to A, approving the transaction, and B, when you negotiate terms with a buyer, especially price terms. First, duty of loyalty. If you are on the other side of the deal, you must disclose material, important facts of your involvement to the shareholders so they can make an informed decision when approving the transaction. For example, if you are on the seller's team and you also own equity in the buyer's side, you need to disclose this. Duty of care, you must negotiate the best possible terms, including price, in your shareholders' best interest. Note that when shareholders believe that you have breached a duty of care, they may be able to seek appraisal rights, where they go to court to seek proper valuation of the entity or fair value in what they believe that they should be getting. Also note that directors who breach their fiduciary duties might be personally liable for that breach, and that is subject to various charter limitations on insurance and indemnity. So you definitely do not want to breach such important duties. Here are some terms you should be aware of as they pertain to allocating financial risk. The first are reps and warranties. What are these? These are assertions made by both buyers and sellers on the condition of their business, liabilities, title to assets, ownership of IP, and much more. This is important because if the buyer finds out that a rep or warranty you made is untrue when made or as of the closing date, the buyer can walk away from the transaction. Worse, the buyer is entitled to indemnification for any losses it suffers as a result of your false rep and warranty. Therefore, you should be very careful when making such statements. If you are not sure about a certain statement, like if you're not sure if you own a certain IP, don't say that you do. Do your own diligence. This leads to another important term you should know about: indemnity holdback. When the buyer has doubts that the seller has financial ability to satisfy any indemnity claims that might arise, such as from the rep and warranty, they set aside a portion of the purchase price and place it in a third-party escrow account. Why is this important? It serves as security for the buyer and alleviates potential concerns about the seller's ability to cover post-closing indemnity claims. And this might be particularly on point for startups. Another term regarding the purchase price is an earnout. An earnout is when the buyer and seller disagree on the purchase price. So an earnout is a mechanism that provides for a contingent additional purchase price based on your company's favorable post-closing performance. This performance can be measured in various ways, and that is subject to negotiation between you and the buyer. This can be based on revenue, EBITDA, which Elvis will mention in a couple of slides, or completion of a core product. So when you reach any of these positive benchmarks, this enables the buyer to pay you an additional purchase price that would otherwise not be able to achieve without this type of benchmark. Next slide, please. All right, so here's a hypothetical. Last one. You are the CEO of Skin in the Game, and your purchaser offers $100,000 for your company. However, your team knows the venture is worth more than that. A key scientist has a promising drug that is undergoing its last round of FDA approval. What term should the company consider negotiating with the buyer to receive a higher purchase price? Again, low stakes, just any guesses are fine. A for effort. All right, so yes, correct. The answer is earnout. In light of the previous discussion, once an agreed upon benchmark is reached, the buyer will pay the seller additional money for the company based on this positive performance. And in this case, as the seller, you can condition the additional purchase price on the FDA approval of the promising drug. So this is an illustration of an important term to be aware of when negotiating with buyers, especially as a startup. Now I will hand it off to my colleague Elvis to discuss why you should pay special attention to your company's corporate documents.
Thank you, Ashley. So once you have decided to sell your business, what do you do next? Here are a few things we encourage you to think about in order to prepare yourself. Your corporate documents control how key decisions are made. You should consult your corporate documents to understand what process you have to follow to get the transaction approved by the company. Keep in mind that the process will be different if the transaction is a stock sale or an asset sale. You should also ask, are all shareholders in agreement to sell? If not, then you should check to see if your corporate documents grant you a drag-along right. Drag-along rights grant key shareholders the ability to force all shareholders to sell the business without requiring their agreement to the transaction. So it could be the case that you are the only shareholder that wants to sell the business, but because you have a drag-along right, then you can actually force all shareholders to sell their shares. You should also check to see if your corporate documents make you subject to a tag-along right. A tag-along right is also known as a co-sale right, and it gives minority shareholders the right to participate in a transaction where a majority shareholder is selling its shares. So if you are a majority shareholder and you want to sell your shares because of a tag-along right, then the minority shareholder could actually join into your transaction. If any shareholders are subject to a vesting agreement, then you should consider whether the sale or change of control could trigger acceleration of any shares. When you own shares that are subject to vesting over a period of time, an acceleration clause causes all remaining unvested shares to become fully vested. Vesting can be triggered by a single event, which is called single trigger, or by two events, which is called double trigger. Single trigger refers to a sale or change of control of the business. Double trigger refers to a sale or change of control of the business, followed by the termination of your employment without cause. Founders usually want to have an acceleration clause because it protects them in case the corporation is sold. A company, however, does not always want to grant an acceleration clause because once the shares are fully vested, then founders lose one key incentive to continue working for the company. A potential buyer is interested in what your business owns. This normally is intellectual property, but it can also be real property or machinery. For intellectual property, you should know who has contributed to the intellectual property, and you should make sure that everyone who has contributed has assigned such intellectual property to the company. When you execute an assignment agreement, you give your rights on something to someone else. In our case, an intellectual property assignment agreement gives the company ownership rights over any intellectual property that was developed by someone else. A potential buyer does not want to run the risk that someone shows up later with a potential claim to the intellectual property that the buyer has already paid for. For real property or machinery, you should make sure that your company has all proper documentation that reflect ownership. You should also do your own due diligence and keep your documents organized from the start. You should take some time to check that things like board consents, amendments to the certificate of incorporation, signature pages, and financial statements have been properly prepared or executed. Keep in mind that every issuance of stock has to be authorized by the board of directors. If the board of directors did not authorize a share issuance, then those shares are not valid. Also keep in mind that you cannot issue more shares than the amount authorized in the certificate of incorporation. For example, let's say that your corporation authorized 5,000 shares and you issue all of those 5,000 shares. Later, when you decide to issue more shares, then not only do you need to have board consent to issue the shares, but the certificate of incorporation must also be amended in order to authorize those additional shares. Due diligence is also important if you are subject to regulatory compliance or if you have contracts that are subject to anti-assignment or change of control provisions. An anti-assignment provision could show up in a licensing agreement where the licensor has stipulated that the contract cannot be assigned to another party without permission from the licensor. A change of control provision could show up in a lease agreement where the lessor has stipulated that you have to receive the consent of the lessor before someone else takes control of the lease. Thus, if you have contracts with anti-assignment or change of control provisions, a third party now has a say on who you sell your business to. If you own intellectual property, make sure to check that things like IP assignments, licenses, or registrations are properly documented. Also ask yourself if there are any concerns about possible infringement either by your company or against your company. Also check to see if there are any claims against your company that could potentially lead to future litigation or to other issues. The items listed here are only a few examples, and when you do your own due diligence, there are a lot more potential issues that you should be looking into. Remember that a potential buyer will also do its due diligence on your business, and any discrepancies found will be red flags that may delay closing, increase transaction costs, or lower the sale price. So by you doing your own due diligence prior to starting the transaction, you are learning about potential issues and hopefully addressing them before those issues arise later. If you are not sure of what things could lead to potential problems, you can always ask your mentor or advisor, as they may have some experience on what type of issues that could come up as you're trying to sell your business. So how do you determine the value of your company? The method used to determine how much your business is worth depends on the stage of your company. If your business has historical earnings, then determining a value can be more scientific. However, if your business does not have earnings, then the process becomes very subjective. As Bree mentioned earlier, there are professionals that you can hire to do a valuation of your private company, and these professionals will pick the methods that work best for your business. Additionally, if you're only selling assets, then you don't have to find a valuation of the entire business. Generally, the value of your assets is based on the book value at which you record your assets in the balance sheet. You can then look at the market value of similar assets and negotiate a price that could be higher or lower than the book value. The discounted cash flow method works for businesses that have a history of earnings. The method works by taking data from your financial statements and making reasonable assumptions about the growth of your revenue and the growth of your expenses in order to project future free cash flows. If your company is generating earnings, you can also determine its value by using a multiple of enterprise value to EBITDA. EBITDA stands for earnings before interest, taxes, depreciation, and amortization. EBITDA is used because it is approximately equal to the cash generated by the company, so it measures the earning power of a business. The method works by finding companies that are similar to your business, taking the average of their enterprise value to EBITDA ratios, and then applying that ratio to your business. But what do you do if your venture does not have earnings? One available method is the scorecard valuation method, and it works by comparing your venture to the average pre-revenue valuation of other similar ventures that have already been funded. We then make adjustments based on a range of subjective factors. These factors include the strength of the management team, the size of the opportunity, the value of your product or technology, competition, availability of marketing or sales channels, the need for additional investment, and any other factor that we may think is relevant. The logic is that since the businesses are similar, then the value should also be similar, except for a few adjustments based on the listed factors. Another available method is the venture capital method. The idea behind the venture capital method is that the buyer will purchase your venture in order to sell it later and make a big return on its investment. The buyer will therefore determine the value of your venture at a time in the future when the buyer will exit its investment. The buyer will then determine the current value of your business by taking the exit value and applying the target rate of return that the buyer thinks is required to justify the risk and the effort of taking on the investment. If your venture is like most startups, you will have no earnings, so you will have to show your worth. The buyer has to determine a valuation somehow, but you can take affirmative steps to improve the assumptions that will be made about your venture. You can do things like ensuring that you have a strong management team. You can also show evidence that your concept works by developing a prototype of your product or by beta testing your software. It is more likely that a sale will happen after a prototype or beta test because buyers want to see something more concrete. The entire sale process generally proceeds as follows. Two parties sign non-disclosure agreements which protect the confidentiality of the information that will be shared throughout the process. A letter of intent is drafted, which outlines the key terms of the transaction. Both parties will have some time to conduct due diligence. The buyer will make arrangements for financing the transaction. The parties will then sign a purchase agreement in which the parties agree to the transaction. Generally, a sale of a business has a signing and a closing. Between the signing and the closing, the parties take any necessary steps to complete the transaction, such as complying with any regulatory requirements or getting any required consents. Then, at the closing, payment and transfer of ownership occurs. This ends our presentation. If you have any legal questions or need legal assistance, here's a link to our intake form. We advise on a broad range of legal issues, and our services are available to all BU and MIT students. Thank you. We will now take questions.
How's it going? My name's Matthew. Thanks a lot for your guys' effort. Could you go back to the slide with the VC positioning of how they would come up with a price for a company without earnings? Yep, that one right there. So the target return on investment, is that a general number they might use, or is it based on the round of funding that you might be in, whether angel through Series A, that kind of thing?
Right, so it really depends. The target rate of return on investment, it's just whatever, honestly, whatever the VC thinks it needs to receive in order to invest in your venture. Whether that is in order to buy the entire business at a specific round, whether it's round A, B, or C, it really depends. There are instances where the valuation actually drops after a round, so the target rate of return could actually change. It really depends on what the VC believes they need to get in return.
Okay. Thanks.
Thanks for your question. It looks like we also have a question in the chat. So Olga says, can I sell my nonprofit 501c3 company? My nonprofit is a database website, and it's relying on an algorithm. So most of the time, it depends on where your nonprofit is, but nonprofit companies are normally non-stock, so you would not be able to do a stock sale because there's no technical ownership of the nonprofit in the same way of like a regular C Corp or LLC, for example. But you could sell the algorithm, which would be an asset sale. And that would be fine. You'd be able to do that without setting up an LLC and then assigning the asset to the LLC and then selling the LLC, which you could do, but it would probably be easier to just sell the asset. Oh, Jim, you're on mute.
Keep in mind, this is Jim, I'm the director of the clinic. you can sell it, and you see mergers of nonprofits happen as well. Two things to keep in mind. One, Massachusetts generally is going to review any transaction like that, and they're going to want to make sure that any proceeds of that sale go to whatever purpose your nonprofit was originally set up for. So you can't take the proceeds and give them to yourself as if you were selling your own for-profit company. You would have to follow, you should have a provision in your charter that says what happens if your nonprofit goes away, and it should say that the assets or value is going to, or whatever money is left over, is going to go to whatever purpose you specified there, and that's where it's going to have to go. And we get this question a couple of times a year from people who they've got a 501c3, they want to do something for profit, and as the question asks, they want to set up a separate LLC maybe so that it can own some valuable intellectual property. But the thing to keep in mind is you can't transfer something of value from the nonprofit to your for-profit without paying value for it, because that's essentially rating your nonprofit in violation of the purpose that you set it up for. And second, if you are going to, if the LLC starts out with the intellectual property and wants to let the nonprofit use it, that transaction would have to be in an arm's length value. So the nonprofit couldn't be paying you more than what somebody else would charge for the same service.
Feel free to unmute and ask the questions. We would love to hear questions by voice if possible. But if not, feel free to leave your question in the chat as well.
Okay, got another question. This is Matthew again. So I have a co-founder who I have since bought out, and before he left, he didn't sign the agreement for the IP that we developed together. Is there a way to circumvent him having not signed it based on our, actually, we don't have a signed operating agreement, but we have signed documentation from the lawyer that we used, or attorney that we used to file the provisional patents? Is there a way beyond that, or do I still need him to sign that piece of paper that says I have no right to this?
I mean, it would be a good, go ahead, Ashley, if you want to answer this.
Sure, I'll ask him a question first, and then if that doesn't answer it, jump on. But Matthew, good question, but can you just jog us back to did your co-founder or former co-founder, did he file for that, the patent?
We filed together, and we were using a consultant to build it. So the three of us filed it under our names together when we filed it.
Okay. So I think it is a joint ownership of the patent at this point. And if you never, or he never signed anything that assigned rights to you, I feel like he still has the ability to use the right.
When I bought him out, he signed, quote, he signed over his effort and property, but within the actual filing for the IP, he didn't sign that piece of paper.
So he didn't sign the provisional patent. He didn't sign. He wasn't involved in that process. Sorry.
Yep, he did. The intermediate piece of paper, which we should have signed at the beginning, which said anything we develop together is the rights of the company. That piece he never signed.
Okay.
But he did sign the agreement when I bought him out for everything that he owned or created to go back to the company.
Okay, and that had an IP assignment in it saying that anything he worked on. Yeah, okay. Well, we would have to actually look at the agreements just to check what it meant. And if you're eligible for clinic services, I'm not sure if you're a current client of the clinic or eligible for clinic services, you could always engage us or just speak with your student advocates if you're currently working with the clinic to take a look at those. It's hard to say without actually looking at the document that he signed, whether or not he properly assigned everything over. It sounds like he might have, but again, we can't give you really a definitive answer there.
Gotcha. Okay. Appreciate it. Thanks.
This is Sam. I'm the assistant director. So we are talking about two different things here. There's the general assignment of IP rights, which Bree was just talking to you about, and like she said, we can take a look at that if you're an eligible client. The other thing is the patent application with the USPTO, and they're going to want to see that he has assigned his rights in the application to your company. So that is definitely a deficiency right now if his name is still on it and he's still considered a joint owner. So it's two things you need to have accomplished there. One is confirm that whatever he signed with the company does properly assign all IP. And then separately, the USPTO needs to be informed by a express written document that he's assigned his rights in that patent application to your company.
Okay, thank you.
Any other questions?
Okay, if there are no other questions, we really appreciate you guys coming today.